Life is a living hell for the people of Ukraine. These were the words of UN Secretary-General Antonio Guterres to the 15-member Security Council in February 2023. This marked a year in which the Council had had 40 debates on the conflict and its response since Russia's full-scale invasion. On this occasion, the Secretary-General reminded the UN Security Council of the following. The guns are talking now, but in the end, we all know the path of diplomacy and accountability is the road to a just and sustainable peace in line with the UN Charter and international law. According to the UN, the conflict in Ukraine has erased 30% of pre-war jobs. Millions have been displaced, and nearly 40% of the population of Ukraine require aid and protection. Amongst them, 7.8 million children are reported to be at risk of acute post-traumatic disorder. In this episode, we explore the pathways for justice and the extent to which the international legal system possesses any possibility of prosecuting leaders for what was described by the military tribunal at Nuremberg as the supreme international crime. Namely, the crime of peace, or as it is now reflected in the Rome Statute of the International Criminal Court, the crime of aggression. My guest today is one of the leading voices and writers in this field. Dr. Astrid Reisinger-Coracini is a senior lecturer and researcher at the Department of European, International and Comparative Law at the University of Vienna. Her research focuses on international criminal law, international humanitarian law, and the use of force. Previously, Dr. Reisinger-Coracini was director of the Salzburg Law School on International Criminal Law, Humanitarian Law, and Human Rights. She participated in the negotiations of the Special Working Group on the crime of aggression and has been part of the Australian delegation to the Assembly of State Parties at the first review conference of the Rome Statute of the International Criminal Court that took place in Kampala. I caught up with Dr. Reisinger-Coracini at UN headquarters, during which the ICC was holding its annual Assembly of State Parties. I hope you enjoy this episode. Astrid, welcome to LawPod. We're here at UN headquarters having this conversation at the Assembly of State Parties at the International Criminal Court. Thank you so much for your time and taking this moment to reflect. I want to first introduce the audience to you and through the work that you're doing by asking you to tell us why you are here at the ASP, in what capacity, and linked to that, what are the priorities in terms of a conversation or dialogue on a specific theme that you're going to be focusing on while you're here at the ASP.
Hi, Yasin, and thank you also. It's really a pleasure talking to you. I'm in daily life. I'm an academic. I teach at the University of Vienna. I'm doing international law, and I specialize in international criminal law and international humanitarian law. The ICC has always been a very special interest of mine. And I started going to the Assembly of States Parties. Actually, I started going to the preparatory commission for the establishment of an ICC when I was still a student. I was active with ELSA, the European Law Students Association, and they were part of the steering committee for the establishment of an ICC. There was an opportunity for law students to attend those sessions. And this is how I got hooked. It's really great that I had the opportunity to come back first as an individual expert under the umbrella of the coalition of NGOs for the International Criminal Court. And for quite some years now, I've been part of the Austrian delegation. So I'm here as part of the official delegation. As an academic, I'm in a very generous position that in Austria, the Ministry of Foreign Affairs is very open, also in exchange with academia. And so this is an opportunity for me to participate.
Great. And I think it's a really powerful position to kind of have a point of view on this, because you've seen the civil society side, the work in the context of academia, but also a state perspective on these issues. And so I want to start in terms of how states might approach the many discussions that are being had in the context of the ICC, but more specifically to the crime of aggression, which I know is an area of particular expertise for you. I just wondered if you could speak a little bit more about that, about where are we in terms of the crime of aggression and the discussions or learnings to be had while we are here at the Assembly of State Parties.
Mm-hmm. So I've been part of the special working group on the crime of aggression that was created after the Rome Conference in order to fulfill the mandate of Article 5 bis of the Rome Statute. Your listeners might be aware of the compromise that was struck in Rome, that the crime of aggression was included within the jurisdiction of the ICC, but the ICC was not able to exercise this jurisdiction.
So this was back in 1998?
Yes, exactly. There was a delay until states would come together and adopt a provision on the crime of aggression that would first define the crime and also set the conditions for the exercise of jurisdiction. This was a very long process in a working group that was quite special. It was a special working group, and what was special about it was that it was open to all states on equal footing.
Yes.
So it was not only states parties to the Rome Statute, but all states were invited. Many non-state parties of the Rome Statute also participated in the negotiations, and that led to the adoption of a provision of the definition of the crime and the conditions at the first review conference of the ICC statute that was held in 2010 in Kampala, in Uganda. And the decision that was taken at the time was a compromise. I was told once that a good compromise is when nobody is really happy. So it was a compromise. It was an important one because it was really a consensus adoption of the definition of the crime. And we had jurisdictional conditions. But still, the ICC was not able to immediately exercise this jurisdiction, so there was another delay. So in Kampala, part of the compromise was that the Assembly of States Parties would need to activate the exercise of jurisdiction over the crime of aggression, and also there needed to be a minimum number of ratifications. So these 30 ratifications were fulfilled, and in 2017, here in New York also, at the Assembly of States Parties, the exercise of jurisdiction was activated. That's 2017.
Yes.
And there have been some controversies, to say the least. Well, what we have come up with is a jurisdictional regime for the crime of aggression that is different from the default jurisdictional regime. So one of the main compromises that was reached at Rome for the crimes falling within the jurisdiction of the court, if we do not have a referral by the Security Council, because then it does not really matter whether a state that is concerned is a state party to the Rome Statute or not. But otherwise, we need to have a link of jurisdiction.
Yes.
So either the state on the territory of which crimes occur or the state of nationality of the offender, one of them must be a state party to the Rome Statute. And one of the main compromises at Rome, or one part of the package deal, was that this is in the alternative. One is enough. So in a way, if a state adheres to the Rome Statute, they can traditionally protect their territory. So if crimes occur on that territory, the court has jurisdiction independent of who is committing those crimes.
Yeah.
And I always thought that this was a very important part of the compromise, and also a way, an incentive for states to become part of the system, and also an important protection of those states. And the jurisdictional regime that was set up as a compromise in Kampala does not allow for that. There are two exceptions from the exercise of jurisdiction of the court. One relates to states parties to the Rome Statute that have not accepted the amendment. They have a possibility to opt out.
Yes. Yeah.
And there's also an exception for non-states parties. So the court cannot exercise its jurisdiction when the act of aggression underlying the crime of aggression is committed by a national of a non-state party or on the territory of a non-state party.
Yeah.
I think the easiest way to explain is that if we are talking about an act of aggression, which is an act of state, which is a precondition for individual criminal responsibility, only if the act of state is committed by a state party to the Rome Statute, which has not opted out of the jurisdiction of the court over the crime of aggression, only then the ICC can exercise its jurisdiction. And we have had, some would say, in the last 1.5 years, and some would say in the last 9 years, we have seen acts of aggression being committed against Ukraine, mainly by the Russian Federation, but since February 2022 also by Belarus.
Yes.
And we suddenly have a situation where the ICC has jurisdiction. Neither Ukraine nor the Russian Federation nor Belarus, for that matter, are state parties to the Rome Statute, but Ukraine has used the possibility to accept the jurisdiction of the ICC ad hoc in accordance with Article 12.3 of the ICC statute. So they have done this, so the ICC has jurisdiction over the situation in Ukraine, and there's an active investigation going on. At the same time, the exercise of jurisdiction over the crime of aggression has been activated, so the ICC also has jurisdiction over the crime of aggression, but yet it cannot exercise its jurisdiction over the crime of aggression in the situation of Ukraine, because of this very specific constellation that was set up in Kampala. And I think this has awoken some states, that this is a situation that is not tenable, that is not explainable to a wider audience, and that is also not favorable to the court, because people look at the court and they say, why does the court not exercise its jurisdiction? The situation is there, the crime is there, and it's really difficult to explain why this is not possible. So we're talking about a gap in the jurisdiction of the ICC with regards to the crime of aggression, and there have been several suggestions how to fill this. One is very focused with regard to the situation in Ukraine. That would be the establishment of an ad hoc tribunal. It's not an ideal situation. We thought with the establishment of the permanent International Criminal Court, we would not need any more ad hoc tribunals, but since the ICC cannot exercise its jurisdiction, this would be a possibility. But there has also been the suggestion, well, we need to look into the future, and we cannot only look at this one specific situation, but we need to change the situation in general. We cannot have another situation in 5 or 6 years when we see another act of aggression maybe committed against a state party of the Rome Statute, or let's say a state that then accepts the jurisdiction of the ICC, and then we start again to discuss whether we need a special tribunal. From a very early time on, several states have linked these two issues because they see the need for a quicker solution for the ongoing situation in Ukraine, but they also see this cannot be a standalone solution. It needs to be linked to a broader reform of the jurisdictional regime of the Rome Statute. This brings me back to New York because now a conversation has started whether there is a possibility, whether states can come together and generate agreement, the jurisdictional regime. And one should also have in mind that at the time in Kampala, when the definition for the crime of aggression was adopted, there was a provision put into the resolution that said that there must be a review of the amendments 7 years after the start of the exercise of jurisdiction. That was in 2008. So 7 years, we have a mandatory review coming up in 2025. And that's not very far away.
No.
So if one wants to make a meaningful contribution and maybe actually arrive at a possibility to improve the system, I think it's really time to start this conversation. And thankfully, other states have thought in the same terms, and that's why I'm here. So there are talks among states parties here in the margins of the Assembly of States Parties, and there are also side events, which are very important events in addition to the official program of the Assembly of States Parties, where NGOs have a lot of possibilities to bring input and express their views, and where specific topics can be discussed in a more informal way.
Yeah. There is so much, and thank you for that incredibly detailed visual of what's been happening, I want to take us back to Kampala and then connect it back to what's going on currently. I think it's very interesting that if we look back to 2010 in Kampala at the review conference, I think there was some bit about the ways in which international lawmaking was so attentive to negotiating these diplomatic pushes and pulls that were going on and the horse trading. But I think it was also interesting to see how the forecasting of what the crime of aggression might look like, right? Both in terms of definition and the exercise of jurisdiction. So we have law, but then sometimes a situation occurs that makes us all think, oh dear, we've drafted something, we've passed something, we've worked so hard, but then in practice it's starting to undermine what in fact is the purpose of criminalizing this crime in the first place. We have an international criminal court, we have the crime of aggression on its books, but we have these, and I love that word of the constellation needed in order for the court to then be able to activate itself with regards to that. And you see the barriers and challenges to that in the context of Ukraine. But what's interesting is that moving forward to that 2025 date, how does one do international lawmaking better, learning from the past that, you know, we can forecast some things, but we may have a case study that reminds us we've created loopholes, we've created a gap in the law, and how do we rectify that? So in 2025, how do we do lawmaking differently? Lessons learned from Kampala and now currently in order to take that forward?
That's difficult to answer. So I think I have a slightly different take, speaking very personally here as an academic. I think it was very clear that we created a loophole at the time. And many states, probably a majority of states, was not happy with this. But they accepted it as part of a compromise because it was important to have the law in place. And there was no way that we could, or at least that was the general feeling, that we could not go further, we could not get more. So I don't think that this has changed. What has changed now is the political will of some states to go further, partly because of the Russian aggression against Ukraine. So I think there something has changed, and possibly this can influence now the discussion and the way where to find the consensus.
Yes, yeah.
And well, as you said, looking back at Kampala, I think there was one aspect which we cannot forget, because all the way to Kampala, I think one important aspect was that the definition was agreed upon.
Yeah.
So there was a slightly technical process which helped finding the compromise. So we went into Kampala with a mainly agreed upon definition, and nothing is agreed until everything is, but the special working group had adopted the definition by consensus. But what was mainly open were the question of the conditions for the exercise of jurisdiction. And one part of that discussion was the relationship of the International Criminal Court with regard to the Security Council of the United Nations, and the discussion whether the Security Council has absolute or is the only organ
exclusively able to,
so whether the Security Council has exclusive authority to determine that an act of aggression has taken place, or whether it has the primary authority and responsibility. All the problems that were associated with this, if we, for instance, would have an outside organ that is not a judicial organ determine that an act of aggression has taken place, if that organ does that, what about the rights of the accused? What about the independence of the court? But in the practice of the Security Council, this would not even be the most problematic part. But the problematic part is that they never do that. They do not say that an act of aggression has taken place because it's not necessary to invoke Chapter 7. You can be more general. We are acting under Chapter 7. There has been a breach to international peace and security. There's no need necessarily to invoke the terminology of an act of aggression.
Yeah.
So that was even the higher fear of states parties, that if the ICC depends on a decision by the Security Council and this doesn't come, then we will never have any prosecution. So I think this was one limb that was very well dealt with, and it was also part of a compromise, but we have a possibility of the International Criminal Court to proceed even if there is no decision of the Security Council that an act of aggression has taken place. And if the Security Council actually decides that an act of aggression has taken place, then this is an important piece of evidence for the court, but it's not mandatory, it's not binding upon the court. So I think this has been quite good balance that could be struck in that regard. The other problem that we had was a combination of the compromise that was reached in Rome, given the fact that crime of aggression was already included within the jurisdiction of the ICC. So many states thought, well, we only need to complement the Rome Statute and actually the provision that deals with how to bring aggression fully into the exercise of jurisdiction, Article 5.2, which is partly now deleted for those states that have ratified the Kampala amendments, but it only refers to an adoption of a provision and not to any entry into force. So it was always seen as a special position in the Rome Statute that agreeing on the crime of aggression was not a full amendment to the Rome Statute. But as Dr. Clark, who we both know very well and who has also been very active in the discussions, he always talked about the completion of the Rome Statute. We adopt by a 2/3 or consensus, and that's sufficient. So we had states with different views, one that had the position that the crime of aggression was already in there, and we just need to complement, and the others who thought, well, this is just a placeholder, but of course you need a proper amendment to bring the crime of aggression in. And then we have the very infamous amendment provision that deals with amendments to Article 5, 6, 7, and 8, the subject matter jurisdiction of the court. And the infamous last sentence that specifies that the court cannot exercise its jurisdiction over nationals or crimes committed on the territory of a state party that has not accepted the amendment. And that kind of directly undermines the jurisdictional regime that we see in Article 12, which is applicable to genocide, crimes against humanity, and war crimes. This was really the main issue. It's like state consent coming in and the state being able to shield their nationals from prosecution. For the sole fact that a crime is being added later on. And many states were not willing to accept such a regime for the crime of aggression because they had the firm understanding that aggression is not coming in later. It has always been there starting from 1998. So this was one of the controversies, and it was very difficult to strike a compromise on that. It was done in a way to build in a possibility for those states that thought aggression was a new crime to be added and would be under a different jurisdictional regime, to give those states parties this option, but at a slightly higher cost, because what was built in to the provisions on the conditions for the exercise of jurisdiction over the crime of aggression was an opt-out regime. So that was the compromise. But the compromise was contested after Kampala. So the whole discussion about whether aggression was already in or it had come in later, and whether the second sentence of Article 121, paragraph 5 was applicable, continued until the activation decision. And this is what still haunts us today.
And I think it would be useful to tease out why some states would be very hesitant to see the crime of aggression not only included in the ICC statute, but nevertheless come fully alive, as it were, fully flourish within the context of the Rome Statute regime. Why would there be hesitation by some states towards this particular crime, more so than genocide or war crimes or crimes against humanity?
Yeah. So one aspect is certainly that if we have a difference in the structure of the crime of aggression vis-a-vis the other crimes that fall within the jurisdiction of the court, then we have much more state influence. I'm not saying that only state organs can commit the crime of aggression, because also non-state organs can, but it's so intrinsically linked to an act of state that underlies the individual criminal responsibility that states are of course much more sensitive with regard to the crime of aggression. I usually counter-argue that by saying, well, of course, genocide, crimes against humanity, war crimes can also be committed by non-state actors, but the problems that you fear with regard to the crime of aggression are the same if you're talking about state organs being engaged in the commission of genocide, crimes against humanity, or war crimes.
Yes.
So if you go into the details, I don't really see the difference. I mean, yes, non-state actors cannot commit a violation of the prohibition of the use of force that would then amount to individual criminal responsibility for the crime of aggression. So that's a difference. One aspect that has very often been brought forward is the fear of political prosecutions.
Yeah.
That the discussion about exceptions from the prohibition of the use of force, the question of unilateral, unauthorized humanitarian intervention,
yes,
the limits of self-defense in accordance with Article 51, that the law, I think Professor Kress usually uses the term of gray areas in public international law, where there are different views. The fear that there might be politically motivated prosecutions. So
more so than genocide or crimes against humanity?
It seems. I cannot explain that.
Yeah.
Maybe there's more confidence that the state organs will not engage in a genocide, but maybe some concern that if a state is military active abroad, and if the borderlines of criminal responsibility are not crystal clear, that there might be more room for allegations. But I'm not in the mind of the legal advisors of
these
such
particular
states. And a third aspect, of course, that we have is the leadership nature of the crime of aggression. So the crime of aggression cannot be committed by everyone, only by persons who are in control or direct the military or political action of a state. And as I've said before, that's not necessarily a state organ. It can also be someone from outside that has such influence. But it's a very limited circle of perpetrators. So the idea was really, with the example of Nuremberg, where the most serious perpetrators, the major war criminals, as it was called in the statute of the Nuremberg Tribunal, those empowered, those that take the decisions to go to war, that they would be the ones that are responsible for the crime of aggression, and not a foot soldier that has no influence in the decision of a state. And that, of course, also brings the crime of aggression closer to the higher hierarchies of a state.
Yeah.
And maybe there's also a more protective will in that regard.
And then on the other side of the argument, if we could explore that a bit more, I think there are so many reasons why it is a good thing that we are where we are with the crime of aggression, that it is in fact part of the ICC statute. But I think what would be useful to talk about is, why is it important to have this crime within the purview of individual criminal responsibility? So not just talking about acts of aggression, state aggression, and in our minds imagining aggression to only be something that invokes the entity of the state. But that as a normative development in international law, why was it important in 2010 that we saw aggression included in the Rome Statute, or come to fruition, as it were?
Yeah, I really think this goes back to the very early days of international criminal law and the Nuremberg Tribunal, where in the judgment you can read the term of the supreme crime, crime of aggression. And of course, crimes against peace at the time. And in 1945, I think there were two ways crimes against peace were really... One was that the prosecution of crimes was linked to crimes against peace, because we had 3 crimes within the jurisdiction of the International Military Tribunal in Nuremberg and the International Military Tribunal for the Far East. Crimes against peace, war crimes, and crimes against humanity. So war crimes at the time were crimes in an international armed conflict.
Yeah.
So they were kind of linked to crimes against peace, because one state must have started this international armed conflict. And with regards to crimes against at the time, we also had a link to one of the other crimes. So in a way, the prosecution of the other crimes were linked to crimes against peace. And the other reason, I think, why crimes against peace had such a special value in Nuremberg was the prosecutorial strategy. That's really, in particular in Nuremberg, the conspiracy was the main theme from which all other counts flew.
Yeah.
And this has changed a little bit with the development after the creation of the United Nations and the changing of conflicts, going away from international armed conflicts more towards non-international armed conflicts. But we see it again very clearly with regards to Ukraine.
Yes.
If there had not been the crime of aggression, the other crimes would have not flown from it.
Yeah.
So war as such creates an environment that facilitates the commission of other crimes under international law. So it still has this catalyst function. This is why it's so important that we are not looking only into what is happening during the time of an armed conflict, but also at the beginning of the armed conflict. And there's another point that I think is a more contemporary one, because for a very long time the argument has always been, well, who is the victim of the crime of aggression? It's the state. And, well, who cares about the state? It's an entity. No, but it's not true. One of the elements of a state is its population.
Yes.
There are humans that are being attacked.
Yeah.
And there are humans that are being submitted under the rule of international humanitarian law. And don't get me wrong, international humanitarian law is very important. It helps humanizing atrocities that are being committed in the context of an armed conflict. But it also creates conditions where your life is worth less. Because even if you're a civilian and you are not being directly attacked, you might be collateral damage, and this is not a war crime, so nobody will be held accountable for you, for your death. But as part of the crime of aggression, such destruction, such death are also part of the bigger picture and also part of the conversation. So we could talk about civilians that are collateral damage being victims of the crime of aggression. Or you could even go as far as some scholars have done, if we have a system of mandatory enlisting in an army where people do not have the choice to go into war, that also soldiers of the aggressor state may be victims of the crime of aggression. And certainly those soldiers that are on the other side and are defending their country.
And so it's interesting to think about this in alignment with the UN Charter, a document that's the foundation of a collective security institution, right? With all the things the UN has done and the evolution of it. But when we think about war in the context of what the Charter does and the prohibition on the use of force and the exceptions within the Charter regime, would you accept that by including the crime of aggression in the ICC statute, it is a demonstration that that denouncement in the Charter is not enough in international law, and that one needed to, in fact, evolve it to the space of international criminal law for further denouncement or further prevention? Why extend it to that scope? Why was the UN Charter not enough when it came to prohibiting war, letting states know on notice that war as the supreme crime should be avoided at all costs, and then we have the exceptions therein?
Well, one point is that international criminal law came before the UN Charter. So the developments with regard to individual criminal responsibility, even if they did not go very far after the First World War. But then you had Nuremberg, and this is before the adoption of the Charter, the prohibition of the use of force, and also the main movement that we have seen with regards to human rights, for instance. So it's kind of precedes. So in a way, one could say, well, now we created broader obligations and a broader protective regime under the UN Charter, and one might have hoped that this is enough. But we do have the institution of international criminal law already from before, and I learned international criminal law with Professor Trichter at the University of Salzburg, and this is, of course, comes from him, but every society can protect its highest values, also ultima ratio by way of criminal law, and so can the international community. So for very serious violations, there's also the possibility of individual criminal responsibility. And I think it's one of the most important achievements of Nuremberg to pierce the veil of sovereignty, because we're not only talking about entities, it's not abstract entities, it's indeed people who take decisions. And if that people had not taken decisions, a lot of suffering would not have happened. So it is important to pinpoint specific perpetrators. The other aspect then would of course be to also avoid collective punishment. But it is humans, it's individuals, it's people who take decisions which are then bringing into motion a state machinery. And in many instances, this is then also attributable to a state, but it's still the individual decisions. So, I mean, what we have with regards to the crime of aggression is that with the UN Charter, the scope of protection of the unlawful use of force was quite broadened. If you compare it to before, what we had, there was the Kellogg-Briand Pact with the prohibition of wars of aggression. So in a way, if this is the foundation and peace and international security is already the highest value that we have under the UN Charter, we're still making a difference between the highest values and parts of the highest values that require or merit even more intense protection. Because not every violation of the prohibition of the use of force, probably not even every act of aggression is criminalized, but only those that are manifest violation of the UN Charter. So it's really a very narrow definition, which does reinforce the power of the prohibition of the use of force. Convinced of that.
So when we are criminalizing aggression, are we stepping towards peace, or are we leaning and mitigating insecurities? Because you said a really interesting phrase there about exactly the kind of UN Charter framework around peace and security. And I think there are distinct things there when we think about peace and building peace, sustaining peace and what that looks like, and then mitigating and responding to security threats, international peace and security, but international ways in which security, global security, can be threatened, can be breached, can be put in jeopardy through aggression. But that doesn't necessarily mean we're moving towards peace, or in fact, does it? What is the relationship between peace and the crime of aggression?
Well, we can have probably a whole podcast about the notion of peace as the absence of war or the absence of fear and need and want. So what we are probably talking about in the more narrower environment of international criminal law is the question of deterrence, right? Does the fact that certain acts of aggression are being criminalized deter perpetrators? And
what's your view on that?
Well, I'm an international lawyer, or I deal with international law. I really think this is more a sociological, criminal question. We assume that deterrence is a factor, but it's very difficult to prove that something has been deterred because obviously it does not happen. So I tend to believe there is an element of deterrence, but I think the fact that the prohibition is much broader is a very important factor, because I would expect from world leaders, and I know I might be disappointed, but I would expect that they are not walking the narrow path between just unlawful and starting to be criminal, but they would plan their action in a way that it avoids the unlawfulness already. So if you take the charter seriously, you're very far away from even getting close to a threat of criminalization.
Yeah.
So if you cross this border already, either you rely then on your legal advisors, but I would really hope that people rather stay away even from this larger area of the prohibition. So we step up the game in a way to make clear that persons that act for a state cannot hide behind a state, and that they have ample warning at the much earlier stage when they even possibly cross a border of the violation of the prohibition of the use of force, because it is much broader. So then there's really no excuse anymore when you cross the next border.
And given the changing nature of warfare, going from interstate, more intrastate, but still seeing a plethora of the way that our understanding of war materializes. Do you think the crime of aggression in the ICC statute is in readiness for cyber warfare?
Well, there have been studies already how cyber activities are already covered by the crimes within the jurisdiction of the court. And of course, cyber attacks, if they are used in a way that amounts or is parallel to the use of force, I see at least a good argument to include this. I remember from the negotiations that there were a few states that already in the run-up to Kampala were very strong in the position and voiced it as part of the negotiations that they believe cyber attacks would be covered by the definition of the crime of aggression. But it has not yet been tested in practice, of course.
Mm-hmm. And my final question is, and thank you so much for such a wonderful, wonderful conversation about this. I wonder what we learn by understanding the concept of justice and international justice and international criminal justice. So the concept of justice, if we understand that through the framing of the crime of aggression. So when we look through the lens of the crime of aggression, what do we understand about the concept of justice and what it means?
With regard to the concept of justice, it varies, now does it not, from affected communities, different persons that are directly affected by the commission of violence against themselves, against loved ones, those living in the context of warfare. What I hear in the recent example with regard to the aggression against Ukraine is that the aggression as such is very much seen as the source of the evil, not only of the atrocities that are being committed, but also the denial of the existence of an independent state. That this is a very important factor also that plays in it. And then I guess it's a combination of the overall aggression that is taking place, the everyday fear of attacks, people being directly affected. It is probably also important if you have single war crimes, let's say rape, sexual, gender-based violence, or murder as a war crime and as a crime against humanity. I can assume, and this from survivors, that it is important to seek justice in individual cases, but very often you also have a situation where the direct perpetrators fall in action. They are not even alive anymore, but there's still the injustice that is being felt. And one knows that it is part of the systemic violence that you experience. So I think it is an important part of reconciliation and getting to grips with the past, that this is part of the broader conversation. But I'm not sure I could answer this question.
No, I think that was a fantastic answer. And I think it helps us to remember about that bigger understanding of like the fact that war itself is not something that is erased or separated or uncoupled from human suffering. The very fact that war itself exposes and causes so much suffering beyond the individual atrocities themselves, but it opens that space for atrocities. It's that wider conditioning, it's that wider setting. And the international community, in speaking to that and attaching responsibility to individuals, I think has much to do in naming war as something that is injustice in and of itself. So it is useful to our thinking. And thank you so much, Astrid, for your time, for your reflections, for those incredibly detailed thoughts. And I have thoroughly enjoyed listening and learning from you, as always.
So thank you very much, Yasin. It was really a pleasure talking to you. It was great meeting you again.